Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. About to sit down in the studio. Had some stuff that I was going to record today when all of a sudden news broke that the state of California had yet again taken another one on the chin. The Chicago White Sox, the Colorado Rockies right now, of gun control legislation appears to be the state of California because they routinely get it handed to them, and this time by the Ninth Circuit. How bad is it when the Ninth Circuit actually strikes down one of your gun laws? What are we talking about? We're talking about California's crazy law that requires background checks to purchase ammunition. That is no more, according to a 3-judge panel in the Ninth Circuit. So today, let's spend a few minutes and let's talk about the Ninth Circuit strikes down California's ammunition background check law. Okay, America, listen, if you don't have this crazy gun law in your state yet, don't worry, it exists in California, which means there is a possibility that it could end up in your state as well. We're talking about California's crazy law that requires background checks before you purchase ammunition, and specifically the case of Rhode v. Bonta. This is a case that Judge Benitez originally got his hands on, enjoined the law. It went up to the Ninth Circuit, was remanded back on a GVR, essentially saying, well, do over again. Shockingly, Judge Benitez came to the same conclusion, then got back to the Ninth Circuit, enjoined. The Ninth Circuit, of course, stayed that injunction, and away we go. We now get before a 3-judge panel, which on a 2-to-1 vote has found this law to be unconstitutional. Now, to give you an idea of how this 3-judge panel of the Ninth Circuit set this issue up in finding the law unconstitutional, they authored, California residents cannot bypass face-to-face transactions with licensed vendors by purchasing ammunition in another state and bringing it into California. Therefore, while California residents may buy ammunition remotely, such as over the internet, they may not access the ammunition without a face-to-face transaction in California. If residents purchase ammunition outside of California, they must have the ammunition delivered to a licensed ammunition vendor for delivery pursuant to the procedures set forth in Section 303(1)(2). And while that sounds like a pain in the ass, which it is, let us remember that this, of course, not only adds delays, it adds cost. Because if you don't time everything just right, well, then that in-state vendor is going to be hanging on to your ammunition. You think they're going to hang on to it for free? No, of course not. And as the Ninth Circuit pointed out, the purchaser must agree to the storage fee before the vendor receives the ammunition, but the department places no limit on the amount of money that the vendors can charge for storage. Oh, and those licensed vendors, yeah, they can just deny a transaction for any old reason and make you go back to square one. Now, this goes beyond an as-applied challenge. This is not just applicable to Miss Rhode. This is an on-its-face challenge. And as the Ninth Circuit points out, because this appeal involves a facial challenge to California's ammunition background check, Rahimi directs us to consider whether the law on its face fits within the plain text of the Second Amendment and this nation's historical tradition. Now, of course, the state of California is arguing like, hey, you got the right to keep and bear arms. It doesn't say anything about ammunition. And this is the disingenuous arguments you get out of these civilian disarmament states. The Ninth Circuit was not persuaded, however. They have ruled. The Supreme Court has indicated that the Second Amendment protects operable arms. C. Heller, holding that a requirement that firearms be kept inoperable is unconstitutional. Because arms are inoperable without ammunition, the right to keep and bear arms necessarily encompasses the right to have ammunition. So the state of California had argued with a straight face that the Second Amendment was not even implicated in this problem at all. The Ninth Circuit, however, has ruled, therefore, at the first step of Bruin, the text of the Second Amendment applies to the right to keep and bear operable arms, which includes the right to have ammunition. Because the right to keep and bear arms includes the right to keep operable arms, rules on ammunition acquisition implicate the plain text of the Second Amendment if they meaningfully constrain the right to keep operable arms. Okay, that is huge. Meaningfully constrain, okay, that's the standard that's being used here. Does all of this extra hoops to jump through, added cost, all sorts of delays and everything like that, does that rise to the level of meaningfully constrained? Well, the Ninth Circuit has ruled in the affirmative as follows. Given the fees and delays associated with California's ammunition background check regime, and the wide range of transactions to which it applies, we conclude that in all applications, the regime meaningfully constrains California residents' right to keep and bear arms. Thus, it is not a presumptively lawful regulatory measure. That's right. In all applications, this is a successful facial challenge to this statute. Now, believe it or not, the Ninth Circuit, and this should come as a shock to no one, actually was more than willing to still apply the more nuanced approach, the watered-down version of analyzing the history here, pursuant to Rahimi. But even under that watered-down, nuanced approach, the Ninth Circuit has ruled. To determine whether the government has met its burden at the second step of Bruin, we consider whether the historical analogs proffered by California are relevantly similar to California's ammunition background check regime. Okay, so understand, they are giving them the relevantly similar path out of here, which means you just gotta be sort of close or similar in nature. It still gets down to the how and why, and this is where it falls apart for California. As the Ninth Circuit has put it, even assuming that the why of California's ammunition background check to ensure that prohibited persons cannot access operable firearms is relevantly similar to the why of the surety laws, its how is unquestionably different. And despite the fact that California tried all sorts of different historical laws, and it's the usual suspects, it's the gunpowder storage, it's the Bowie knives, it's all the things that they come up with, a three-judge panel of the Ninth Circuit has found, because none of the historical analogs proffered by California is within the relevant time frame or is relevantly similar to California's ammunition background check regime, California's ammunition background check regime does not survive scrutiny under the two-step Bruin analysis. Now, you may recall this video, which we happen to do from the state capitol grounds of California down in Sacramento, and it was about the dreaded dangers of Bruin footnote 9 and how what was designed to be a shield has turned into a sword for civilian disarmament legislation. Was the court convinced, however, that these objective criteria, as laid out in Bruin footnote 9, means that the background check system survives? Absolutely not, and this is how they dealt with it. Bruin made clear that it did not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. Bruin's examples of how shall issue licensing regimes could be abusive were not exclusive. Moreover, Bruin shed no light on the constitutionality of an ammunition background check regime, which is meaningfully distinguishable from a shall issue licensing regime. So, in going through all of the state of California's arguments and taking a look at the pages and pages and pages of history that they offered, none of which was even relevantly similar, a three-judge panel of the Ninth Circuit has ruled that California's ammunition background check is, by subjecting Californians to background checks for all ammunition purchases, California's ammunition background check regime infringes on the fundamental right to keep and bear arms. Because California's ammunition background check regime violates the Second Amendment, the district court did not abuse its discretion in granting a permanent injunction. So, as of this moment, California's background check system for ammunition purchases is going to be placed on hold. Why is that? Because the law has been found unconstitutional. What does this mean? It means that Rob Bonta and everyone else over at the California Department of Justice has officially crapped its pants, and they are already working on the appeal to the full en banc panel of the Ninth Circuit. California, you don't need me to tell you what happens when a full en banc panel of the Ninth Circuit gets involved. This case is likely going to be swooped up. Any injunctive relief that is placed upon California residents right now is going to be stayed, and away we go. And then the case will age out like fine wine, a la Duncan v. Bonta and Miller v. Bonta. But in the meantime, America, this is a big win. Because when the Ninth Circuit thinks that your gun law is so bad that they're going to strike it down, you have written one horrible, horrible gun law. And this is a disarmament mechanism that is going to be employed in more and more of the civilian disarmament, or we like to call dirty dozen states, if given the opportunity. So this insanity needs to stop right now, and at least for the time being, a three-judge panel of the Ninth Circuit has done exactly that. Okay, the case once again is Rhode v. Bonta. We're going to link up the court's order down below so you can geek out on it for yourself. Don't have to take our word for it. Now listen, if you got any questions about this, or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you have an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the information on how to do that is there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.